before we start, for Jeremy to introduce yourself, because we're adding someone to the panel who has not been introduced yet. Introduce yourself, tell us why you're here and what your story is and why you were invited to be here today.
Thank you, Rodney. My name is Jeremy MADDOCK. I work as a legal research consultant for a number of lawyers, primarily in the criminal sphere. I've been doing that since about 2010, and I do have a law degree, but my main function, as I see it, is to try to bridge the gap between individuals and the legal system, because criminal law is really where the rubber meets the road in terms of individuals versus the state. And it's an incredibly frustrating problem, because the individual charged with an offense usually in fact, has no resources, usually is in a desperate situation where they do not have the ability to defend themselves or to assert their rights. And the state has all the power, the state has all the money, the state has unlimited resources. And to try and level that playing field is really hard. I see it from both perspectives. I see it from the individual litigant's perspective, and I see it from the lawyer's perspective, the lawyers that are struggling to make ends meet on a treadmill of legal aid funding, which is inadequate and often leaves the defense lawyers at a great disadvantage versus the Crown. So trying to bridge that gap is something I've tried to do. Obviously, it involves the Constitution, it involves interpreting and learning about the Constitution. And when I saw the kind of discrimination and unconstitutional tactics that were going on in Canada during the pandemic, it was clear to me that this was the greatest civil liberties battle in our generation. I was contacted by a lot of healthcare workers and people who'd lost their jobs, and that was the start of my involvement with We Unify as well, was leading the legal team and trying to help these people. And I went through my whole Rolodex of lawyers that I know, mostly sole practitioners, who I was trying to get them engaged, get them involved. And most of them said they just weren't equipped to do it. It was too big of a challenge. And either they didn't have the resources themselves, or they didn't have, in some cases, admitted to me that they didn't have the courage because of the politics around the situation. So I'm very grateful to be in the company of these gentlemen who really are doing something about it, and I've tried to play a role, and I'm going to continue playing a role, and it's just an honor to be here and to see that there are people standing up for justice. I do have a proposed sort of solution or idea, but I'll get to that in a bit, and I'll open the floor up.
Thanks very much, and we also thank you for joining. We also have Christopher Scott up here, and Christopher has already spoken this weekend. Just to recap, that Christopher is the owner of the Whistle Stop Cafe in Alberta and dared to open his cafe and serve coffee and food during the pandemic, and he has been on the other side of the law. He's been targeted for what he did in very strange ways. I wanted I'm going to ask a question, and then anybody can respond. I'm going to point the first one to Omar, but anybody can respond. And let's get the conversation going, including both of you on the ends. Omar, I was wondering about your flu vaccine win. Is there any precedent there that can be used and utilized by lawyers or plaintiffs going forward about the COVID vaccine?
Yeah, thank you for that. Yes, there is. So we have transcripts that are available. Anybody who wants to contact us, we have copies of them. We can give out Bonnie Henry's testimony. We can point to something called the McKinley test, which was the specific test that we argued under, which talks about how employer policies are formed, and so there's certainly that available. Like any other case, and you'll notice this in a lot of COVID-19 vaccination cases, why you don't hear about them once they're finished, unless, of course, they lose, and you hear about them all the time, is if the government is predicting a loss, they will come and settle. Now, good luck settling with someone like Kip Warner, who's never going to settle his case, but a lot of folks that I represent are destitute. And so if you put a big check in front of them and a confidentiality agreement, they're going to take that. And so that's a lot of the reasons that those cases aren't published at this time, but we do have the materials and we're happy to share them.
So in a settlement, you don't win, and then if you don't win, you don't have a precedent for someone else to go on.
You win, but you just don't have a precedent.
You don't have you don't have a judgment.
Correct.
Yes.
Yeah.
Okay. Does anyone else want to comment on that about the use of precedents? Or not right now. Okay. So I have a question for Leighton, and that is because you work in the criminal realm. When I gave my testimony to the National Citizens Inquiry, I pointed out that the Criminal Code of Canada has a section for fomenting hatred against an identifiable group. And this came to me as I was reviewing CBC's work that rubbed me the wrong way during COVID, that the unvaccinated became a very identifiable group because we had to sit outside. We couldn't go inside. We couldn't fly by virtue of the absence of what we could do and the freedoms that were taken from us. And then Sean Buckley, the main lawyer for the National Citizens Inquiry, pointed out two other sections that involved criminal negligence causing harm or causing death, which were if the CBC and other, I've concentrated on the CBC because we pay for it, but all other media are doing the exact same thing. But could there be a use of these three sections of the criminal code, the two in negligence and the one in fomenting hate? Do you think that could stick, or is it too much of a stretch?
Well, there's a couple of problems with that conceptually. One is the legal concept of proximity. And so you always have to have a connection between an action, in this case a criminal action, and the actual result of that, the resulting harm. And in a case like that, you've got a problem in terms of in between what the government does, there's a layer of decision making by individuals in terms of how they process that information, how it impacts their actions. That's in the context of something like criminal negligence. I think that there are civil opportunities in terms of the government's purchase and promotion and provision of the vaccines. I think that is very fertile ground, and that's one of the cases that we're working on right now in terms of a class action, a vaccine harms class action. In terms of the unvaccinated, that's a very intriguing concept that I'm working on. Actually, I'm looking forward to having a private conversation with Omar about this idea of is it possible to frame, for example, a class action which would bring civil liability against the government, against Justin Trudeau and others for saying things and doing things that cause harm. That is restriction of mobility rights, discrimination under Section 15 in terms of eligibility for employment insurance. There's a whole series of things that I think are tortious, that's a legal word, actionable. But in the criminal context, the problem that you're going to have is who prosecutes criminals in this country. It's the state. And if you talk to Ken Drysdale in Manitoba, as you know, he was one of the panelists in the National Citizens Inquiry. He's done a lot of work in this realm, and no one thus far has had any success. Maybe Alan could correct me. I'm not aware of any criminal type prosecutions that have been successful in this country, not even private prosecutions. And the reason why is ultimately the state has the ability to kill prosecutions.
Yeah, I agree with that, and I'd add one other thing to what Leighton said. When you're talking about the willful promotion of hatred, that's a very special crime which exists in the criminal code, and even if the government that wouldn't even get to the point where the government would kill it, because you couldn't bring that because the Attorney General would have to sign off on it. That's how serious that crime is, right? And then just to also expand a little bit upon what Leighton was saying, you can sue the government sometimes for doing some things like, passing laws, but that's very rare. Usually, the justification. Usually, if there's a law that infringes your rights, the solution would be to try and strike it. But if you're going so far as to try and sue the government because of a law that they passed, then you're potentially interfering with the democratic process, because when governments are debating laws, they don't want to be afraid of getting sued for passing a law, right? So the very notion of a lawsuit could put a chill on the democratic process, and that's one of the issues.
In Toronto, there was a pride parade a few years ago, and my client distributed literature surreptitiously pretending to be someone who wasn't a member of the Pride community. And so a $106 million class action lawsuit was filed against this individual who I represented. And I teamed up with a class action specialist, and we successfully defeated the $106 million action. And that took about 2 years to do. We did it in the course of cross motions in the Ontario Superior Court. Now, let me get to the point. The plaintiff in this case, there were several classes of plaintiffs. There were 2 representatives of the entire class, being the Pride community. But the subclass was the Liberal parties of Ontario and the Canadian government. And that included Trudeau, Justin Trudeau, and Kathleen Wynne. Okay? So after we defeated the civil claim, within a month, the Ontario Cabinet somehow decided to prosecute my client for distributing hate literature, even though on the civil action, they didn't even have enough evidence to win on a balance of probabilities. To me, that constituted abuse of process by the government using its executive power and secrecy in cabinet deliberations out of spite to overcome a legal defeat to launch a criminal prosecution because they were so offended. And John Rosen is now representing this client in criminal courts. My client was acquitted, as I expected, but now the Crown has appealed. Now, Rosen's plan for defense wasn't based upon cabinet misconduct. It was simply based on proof beyond a reasonable doubt. And the matter is going shortly in June to the Ontario Court of Appeal. But the whole point is that they proceeded by indictment, which is the most serious way to proceed on a hate charge. But in hate proceedings, truth is a defense under the criminal code. So we'll see where that ends up. But I wanted to throw in that sometimes hate charges under the criminal code are motivated by what I perceive to be malice.
I believe also it's a reasonable belief of the truth is in there, because I read the code, that section recently. Did you have something to add, Alan, or no?
Well, I had one thing to add, perhaps. I agree with everything that Dr. Lugosi has said. But when we're talking about hate under the criminal code, there's actually been a very interesting change which has happened recently. It's an amendment to the criminal code. And it's a new form of the way hate is prosecuted. And Dr. Lugosi is right. Under the criminal code, truth is a defense to the willful promotion of hatred. But there's a new law now that says downplaying or denying the Holocaust will be a crime. It is a crime. And everybody here knows that it's reprehensible to deny the Holocaust. We all agree with that. But what we're seeing is that there's a change where in the past what you've seen are hate speech would have a certain consequence, and that's why it was illegal. But now what you're seeing is that speech is just illegal because of the content itself. All you have to really do is say it.
Words, words, words.
Yeah, so the difference between uttering hate to cause a harm versus uttering hate to deny a historical event. That you're suggesting that there might be a difference in severity of the two.
I think that's a fundamental shift, right? Because now the speech doesn't have to be connected to a consequence. And look, like I said, we all agree that denying the Holocaust is wrong, but what's the next thing that's going to be in the criminal code that is illegal to say?
I just want to add one thing, and I understand what my colleague says about picking the ideal facts, the ideal client, the ideal time to advocate for change. But we as lawyers, we're actually stuck with all of you because you're going to act independently when you choose to do it. How you choose to do it without prior legal strategy or consultation. That throws us into the middle of a real-life situation where we do the best we can. And let me say this. Yes, I acknowledge it takes time, as Umar said, to eventually win what appears to be a hopeless case, okay? But we are advocates and witnesses to the truth. That's our job. In fact, I look at myself, and I think my colleagues do, that we, by speaking the truth, are advocates and witnesses for the truth. That's our job. Because if we don't proclaim what we know to be right and just, we are going to be co-conspirators in a world of evil. All right? So,
Leighton wanted to jump in, and I think he's going to jump on your word evil here.
Well, if I could just piggyback on that, this gets back to my sort of dichotomy between, the tops of the trees and the roots. One of the distinctions between a free and democratic society and a totalitarian one in terms of the way that laws are made is that in a free and democratic society, one that's functioning properly or functioning well most of the time, what you have is you have a situation where the law is downstream of culture. Your laws are words, and they are a reflection of what is happening in the culture. At least that's the way it should be. Because the law is to some degree an expression of the shared will of the populace, as opposed to evil King John's version of law, which was force and will. When that gave rise to the Magna Carta. And what we have in our country right now is we have exactly what Alan's talking about. We have these words being defined at the tops of the trees by force and will. And the whole point of what I was trying to say is we've got to take that back. These are our words. This is our culture, and we have to make them our laws. And when we start doing that, that's when it's going to change.
So I want to get to you, Charles, but just in a moment, because we haven't heard from Christopher yet, and also Christopher and Jeremy are on the other end. They're the guys who we can get us back onto our theme of solution, because they are the litigants and not the litigators. So Christopher, if you have some suggestions about solutions here on our theme.
Well, to be honest, I thought that I was supposed to be pouring these guys coffee.
Well, then get at it, because I don't see any coffee here.
No. I suppose there might be some people wondering why I'm sitting here with these arguably brilliant minds. I have no background in law.
It's qualifier.
Yeah, my pleasure. I have no background in law. I don't have a degree in anything. I'm pretty much average in every way. I have an average job, an average home, blah, blah, blah. I don't really belong in the company of these men, but one thing that I wanted to do is I wanted to give you a bit of a layman's perspective on law and what I've seen and how I've experienced it. So I find myself in a not so unique position in which the judiciary seems to not be there to protect me from the government and ensure that I follow the laws as they're laid out. It doesn't seem to be like that to me. It seems like, in my case, the judiciary is being used as an arm of the government and non-governmental organizations in order to step on me, in order to make me comply with rules and laws that are arguably unconstitutional. So this unique position for me is that I've had to do things like read the Constitution. How many people have read the Constitution Act 1982? Look around, folks. Not very many.
An unusual number, I would say, actually.
Well, in this crowd,
This
there's
audience.
probably more than average. How many people have read the Charter of Rights and Freedoms? How many people have read the Bill of Rights? I want to point out that a Russian immigrant has parts of that document memorized, and I don't. I've lived here my entire life, and I didn't know the laws that are supposed to protect me, except for when we had to memorize them in elementary school and forget them the next year. So I found out that have you ever heard the phrase, if you're confused, you lose? I was very confused about who I was in this country, who I was in this province, and how the law is supposed to protect me. So I had to read those documents. And I've had everybody from all sorts of groups reach out to me and give me some solutions. Some have told me I can just create my own identification with a fingerprint, burn my driver's license. Some have told me that I can make the judge put on different clothes. Some have told me that I can declare myself a sovereign citizen of some turtle island, and I can say that I'm the king and they're in my jurisdiction. Now, you laugh, but some of these things at one point in time may have had some validity, but I would argue now that in this country of 38 plus million people, the majority of these people believe in the laws that we have legislated into existence ourselves. Would you agree with me? Most of us in this country, the vast majority, believe that the Constitution is the supreme law of the country. Would you agree with that? Now, there are some who don't agree with that, but that's not what I'm going to talk about. The people that agree with that, they have the courts, they have the police, they have the guns, they have the jails. And if I find myself on the opposite side of that, I end up at the end of a gun and then put in a jail, which is not very comfortable, by the way. So I choose to believe in the institutions of this country. There's also some other people who have said things like lawyers are all corrupt. Judges are all corrupt. The system's corrupt. The elections are rigged. They're selections, not elections. And my question to those folks, and my question to you, if you subscribe to any of those beliefs, is, and then what? If not for what we have right now, and these men who have spent their lives learning to help us navigate the law, what else do we have at this moment? I spoke in front of a crowd of probably 200,000 people in Ottawa after a man told that crowd that if a police officer was breaking the law, that we should arrest them. What happens if you try and arrest a police officer in this country? You find yourself at the end of a taser, or even worse, at the end of a gun. And it may be true that you could arrest an RCMP officer for breaking the law, but the consequences of trying to do so and the outcome is not going to be what you're seeking. I want to see an outcome in my case that benefits everyone. As a matter of fact, I've had to tell my lawyer I would find a new lawyer if he didn't stop trying to protect me and he didn't start thinking about the bigger picture of precedent that Alan mentioned, who, by the way, thank you for your work with the Democracy Fund, because it's the Democracy Fund that's actually funding my legal challenges. So the reason I say these things, and I'm so long-winded, I'm sorry, is that if we're confused, we will lose. If we condemn every lawyer in this country, in this province and in this country, as corrupt and part of some conspiracy to keep us down, we will lose. Because if not for that, what else is there? We have to stop being confused. And we have to start having some patience, as Umar has said. But believe me, I've accepted the consequence of this in that I will very likely lose the things that I hold dear in my life. Well, I'm talking about material things. I will very likely be persecuted by the government. Last time I was in court, there was 5 state-sponsored lawyers against me. The Attorney General of Canada's office was present in my case because we poked a hornet's nest so much. These bees are swarming around and they're stinging me. And I know this is going to be a long battle. I know it's going to be a long battle. But if we don't fight these battles and we don't stay true to this course, there will be no resolution. We'll remain confused and we'll lose.
Is it reasonable? Both Omar and Charles have asked, but I think you're on this. Is it reasonable, a statement that our judiciary is not protecting us from the government right now? And I'm going to leave that open and see who wants to talk. Charles, Omar, whoever talks.
Yeah, there's a couple things I want to mention in terms of solutions. I've had clients just like Christopher here.
Sorry
and,
about
that. Or,
I apologize for that.
oh, no, we get along great, actually. But let me tell you what I did for a local person here, because this was a solution, and I haven't shared this before, but my client, he drives a car and he says F. Bonnie Henry on it, and he has the Canadian flag on it. Does that sound kind of familiar to some of you? So he lives in a residential complex, or he used to live in a rental unit. And there was a sign, signs were prohibited. In other words, political signs were prohibited in this rental complex. So one day he comes home, and you know the kind of mentality my client has, and hanging from a balcony right in front of his face is what he considers to be a political sign. It's the pride flag and transgender flag. So he spits on it. You haven't heard about this case for a very good reason. Well, what I did was I issued a notice of constitutional question. And in my argument, which is mandatory before you raise it in court, I argue that the Criminal Code offense of mischief must conform to the Charter of Rights. And there's no exception in the law of criminal mischief for political expression against a political sign. And what was the response of the Crown? It was booted upstairs to the most senior Crowns because they usually don't deal with a lawyer on a mischief charge with such a vigorous defense. They stayed the charge. They stayed the charge. Why? Because we're going to win. And that's the kind of aggressive defense you can mount. Now, let me tell you another kind of solution, other than being very aggressive and using the Constitution in litigation. You don't know, but you may wonder something about my background. You've noticed the theoretical component to my discussions. I sound like an academic to some of you. Well, I have to confess, I am also a law professor. I have taught mostly in American law schools, and my specialty is constitutional law, and I have 3 law degrees, including a doctorate in constitutional law. And so what I wanted to tell you was, in conjunction with Umar said, cases have to have an intellectual framework that will succeed, even if it takes a long time. And you will recall that there was a case decided in the early 1970s that dealt with segregation. And with U.S. Supreme Court, in a case called Roe versus Wade, said that if you are in a class of human being that is not legally a person under the 14th Amendment, you may be killed at will. And people interpreted that decision wrongly to say there was a constitutional right of privacy under the Due Process Clause of the 14th Amendment. Well, I was at that time in law school later on, and eventually I mostly did murder cases for an awful long time. I had a 2-year waiting list of clients in custody. But I left all that because I went to the States to get advanced education. And I had a doctorate dissertation to complete. And in that dissertation, I wrote out the blueprint, how to reverse Roe versus Wade. I was the pioneering legal philosopher who set out the legal framework, how the court got it wrong. And my article was published in 2005. And it wasn't until about 2009, there was another academic who wrote about it, and then another series of academics, and then it got into the hands of litigators, and in 2002, Roe versus Wade was reversed. So it took 49 years, okay? But most Canadians don't know, thankfully, because I don't want to be crucified.
They know now.
That it's a Canadian that was behind the blueprint to overturn Roe versus Wade. So I'm telling you, each and every one of you who are lawyers or legally trained, don't worry about the time, effort, and sacrifice the cost of discipleship, which I fully agree with, to do the right thing. Okay? That is vital. There is a cost of discipleship to being a lawyer. And I do want to say one last thing, that the Brown versus Board of Education that was decided in 1954 reversed an 1896 decision of Plessy versus Ferguson, which said separate but equal is fine. But no, desegregation happened. And that took 58 years, which was 9 years longer than Roe versus Wade. And I, as a law professor of constitutional law, it was the 14th Amendment in 1868 that reversed Dred Scott, because then black people became persons under the law. But one other interesting twist to the story, and that is this. Within 10 years or so, corporations became persons. How can that be? They were always intended to be a guard of equality, equal protection for natural human beings. It shows you that the judges of the Supreme Court can get something wrong just as much in the United States as in Canada. And that has never been reversed, even today, over years later.
It's one of the most ridiculous things I always see in the States is that a
So
corporation
anyway,
is a
I
person.
love Umar, I respect him, and I think he's doing fantastic work. And I'd be delighted to work with him on any case.
So I'm getting concerns about the next speakers and the next speakers and the dinner that we have. So maybe we can talk about our solutions. And I'm going to start with Omar, and we'll go down. And if there's a break and anybody wants to come in, it can be a little freewheeling, but we'll do it in that order from here. Oh, this can't be a sign, Omar. You're a white supremacist? What's wrong?
What's happened?
Canadian flag just fell down.
Of course it did.
I just let the white supremacists
So here's, I want to start off with solutions that I know Leighton will build on, and others on this panel, because we've been racking our brains trying to think of how do we fill the void between now and that eventual victory that will come in these cases. One of the ways that I want to start off by talking about it is activism, and activism within unions specifically. 30% of this country is unionized. And the large majority of people who were fired and put on leave without pay as a result of mandates were unionized. Their unions utterly and completely failed them in any sort of representation in this country. I spent about 7 years running one of the largest unions in this country. And what I can tell you is that individuals have so much more power than they believe they do. Getting involved as a unionized employee into your union elections, getting involved in passing bylaws at union conventions, all of these things can make a tremendous difference. And so I want to keep it brief because I want others to jump in, but that's the one form of activism that if you know someone who's in a union or unionized or in those types of positions, they can get involved with their unions and they can make change from the ground floor.
Well, let me say that if you're in a position like Chris Scott is, or like Dr. Lugosi's client with the car is, or with one of the criminal clients who's assisted by Jeremy or represented by Leighton, then you should do everything in your power to aggressively defend that case. Those types of cases are easier to win when you're on the defense, when you're invoking the charter in your defense. I think it's a little bit harder to do it on the offensive, but most of you can't do that anyway. Most of us aren't going to get criminally charged, and we're not going to bring a big constitutional case. I think what everyone can do, though, is they can be a dissident in their own small way, and there are things that people do all the time, people in this room. I think all the homeschoolers who in this room and across the country are actually engaging in an act of dissent. I think when you start up your own business or you work for somebody who starts up their own business, that can be an act of dissent. It can be a solution for you as well. I think, if you read a book like Live Not by Lies, you'll hear Rod Dreher, who will talk about bedrocks of resistance. He'll say, well, form communities, form strong families, build up your church. Those are all different ways that we can exercise solutions right now. They're not legal solutions, but they are solutions. And I'm going to pass it on to Leighton, but I don't think it stops there. I think there are all sorts of different things you can do, and one of the things that you have to do that is critical is that you have to build up an alternative to this prevailing culture right now, right? Because if you have kids, let's say you're homeschooling those kids, you're going to have to provide them with a suitable alternative. So, I would say the solutions are easy. Take them to the art museum, take them to the opera, give them culture, make it attractive.
I think Alan has a great point. I also agree with Omar about activism. In fact, I had Preston Manning on my show, the shameless plug, and he's written many books, all of which are good. One of them is called Do Something, and it's 365 different things that people can do in their everyday lives to make a difference in their communities. And this has downstream impacts. Let me give you one example that's very relevant right now. If you've seen a recent documentary by Aaron Gunn called Canada is Dying, it documents what's happening in cities, especially in Vancouver and even nearby Nanaimo, where the decision by the BC government as an expression of the values, apparently, of British Columbians, is to allow, illicit drug use throughout the province. And that has had devastating impacts on crime. And of course, it combines with the catch and release, bail policies and laws of the current government. And so that's an example of how laws are downstream of culture. There's a culture of permissiveness in terms of illicit drug use in this province, and it's destructive. It's destroying communities. 40% of people in Nanaimo, according to a recent poll, don't feel safe walking around their streets. In Alberta, the lady who's running for our premiership, she's tomorrow, Danielle Smith, her chief of staff is a man who spent 5 years as a drug addict on the streets of Vancouver in British Columbia. And he's brilliant. But what they're doing is, whereas Bonnie Henry says, well, we can't rehabilitate somebody who's addicted to opiates. In Alberta, they're building 10 rehab facilities. The first one's going to open in Red Deer. It's already done. And it's free. Okay? All you have to do is ask for it. So my point is that type of that is the result of that is the will of the people, the population. That could not happen unless you had a culture which thought that and believed that as a value, a statement of value, that rehabilitation of people who are addicted to opiates is really important. We all know that addiction to opiates is a really serious problem. Okay, we all know this, but that's an example of how laws, when they properly express the good, okay, your idea of the good. Sorry to point, how that can make a difference, in just neighboring provinces. So I think activism is very key, but it starts at the level of government that's closest to your door. That's where you can make the biggest difference.
Jeremy?
Yeah, so in terms of solutions, I heard what Chris was saying, and it's such a familiar story to me. People who are, they feel like the odds are stacked against them. 5 government lawyers show up, and they're lucky if they can afford one. And that's part of why the legitimacy of our system is suffering. That's why people believe in these theories about freemen on the land, or the whole system's corrupt, or you just declare yourself sovereign. These people have grievous legal misunderstandings, but those misunderstandings are motivated by a real phenomenon, which is that the system does not appear to be fair. And we need to restructure the system in such a way that there's a level playing field, especially in the cases that affect all of us. So the idea that I have is that when there's a sufficiently important case, like around the mandates, or where there's hundreds of people or thousands of people out of work, there should be a process by which a fair hearing happens that's fair and seen to be fair. So if enough people, for example, were to put their names on a petition and say, this affects me, it shouldn't be one person standing alone against 5 government lawyers. There should be a process where an amicus means a lawyer that's appointed by the court to argue the other side, to argue against government, and should receive the same amount of funding as the government lawyers who are arguing this case. There shouldn't be, thank you, the very specter, the idea of a lone individual, which I've seen so many times up against all the king's horses and all the king's men, it makes people lose confidence. And in a political context, I would pitch this to the government by saying, if you want your system to be legitimate, if you want people to believe in it, it has to be seen to be fair. And create the equivalent of referendum initiative and recall. If a politician is completely corrupt and we all know it, we can do a petition and we can remove that person. We should have the same thing when a law is corrupt and we all know it. We should be able to get it before the courts and have brilliant academics like Dr. LUGOSI bringing that argument forward and making that argument in a properly funded way that we can all be proud to say our system works. And we're not there, but we should strive for that. We should strive for systemic change where individuals can have their day in court and be treated fairly, and a true level playing field. That's what I'd like to see.
I'll just piggyback on that. That's a great point that we haven't talked about that yet, and that is the fairness of the system. One of the endemic problems is, and I have to be careful saying this because I'm a lawyer, is judicial activism. I'll give you an example. John knows when we were in court during the Ingram case, we asked to, in fact, we made an application to cross-examine Dr. Dean Henshaw in person, because that makes a really big difference. Not the same. It's like if you're watching this on TV versus seeing us live, it's not the same, especially in that context. Court is not just an idea, it's a place. And that was denied. And the judge said, well, because COVID. Yeah. The risk was that Dr. Henshaw would get COVID. That's why we couldn't cross-examine her in person. So we had to do it over Zoom. So then we're on Zoom. And the judge is in a room essentially alone. There's one other lady there who's a clerk, not within 3 meters, if that ever meant anything. But the lady that we're in front of, who is deciding our case, has a mask. You can only see her eyes. Okay? So as a lawyer taking this case to court, we're arguing against masking. Okay? This is a hockey analogy. You know you're the visiting team. Okay? That's a serious problem. And not even to get into start talking about judges taking judicial notice, just saying, oh yes, there's something called the pandemic. Wait, don't we need evidence? Okay. We had to wait over 6 months. There was an application December. By the way, we started the case in December 20. We don't have a decision yet. Justice delayed is justice denied, folks. The most important civil case in Alberta. We're waiting for a decision. We still don't have it. Okay. That's a violation of the charter rights of every single Albertan. We don't have a decision yet. Okay. And we had to wait 6 months. There was an injunction. When lockdowns came into effect in December of 20, there was an injunction, and we lost. The Crown produced no evidence. Adding insult to injury, they got 6 months to produce. They didn't have to produce evidence until July. And then when they produced it, it was junk. And that's not me saying, that's Dr. Jay Bhattacharya, one of the authors of the Great Barrington Declaration. He said that they used the same models that they used to predict the weather and applied them to COVID. And this is a guy who builds models. He recognized them, almost like a kid who is copied somebody else's homework, has taken an essay off of Wikipedia. That's what Dr. Bhattacharya said.
So, Leighton,
judicial
this was
activism is
the
a serious
evidence
problem.
you were seeking that justified the initiation of everything,
Yeah.
and they didn't have it.
They didn't have it for 6 months, and in the meanwhile, everybody's locked down. Everybody's locked down during all that time. And they, so judicial activism is a serious, what Alan talks about. That's a serious problem that has to be addressed. And I think it's got to be addressed legislatively. And I'm hoping that when Danielle Smith wins tomorrow, that's going to happen.
Yeah,
We're
let
gonna
me say one more
We're gonna
thing.
wrap it in a moment. I'm gonna give the last 2 minutes to the man who everyone else on the panel defers to.
I need to say something. Judicial activism in British Columbia has gone to the point where lawyers have been directed by the Chief Justice to use pronouns to introduce themselves. And you hear when you appear in court, all the employees of the government lawyers, faithfully obey this. But since I arrived in Victoria, I have never done that. And what I have noticed is I wasn't challenged, wasn't confronted, but I'm not willing to submit to compelled speech. And it seems to me that if I have to use pronouns, that means I'm submitting to woke ideology. And I think that lawyers need to stand up and not be intimidated by what I consider is an unconstitutional directive. And I would just want to show you that the extent of judicial activism isn't just controlling the court process or the evidence, but it extends to the behavior of lawyers. And let me conclude my other thought, which is this. The lawyers before you here who believe in freedom, most of us are broke. We're not rich people. And we can barely survive. And sometimes we don't know if we can pay our bills month to month. Why? Because we're taking your cases. And that's the reality. Now, if you're, as individuals, what you pay a lawyer is tax deductible, that would make a difference because it's not a level playing field. Corporations write off legal expenses as businesses. But individuals engaged in criminal defense, family law, making estate planning, you're taxed by the legal services tax. And then to add insult to injury, you can't even use your income tax form to deduct your legal expenses. This is institutionalized unfairness that targets the middle class because the very poor get legal aid and those who are working for corporations or the very rich don't need tax deductions. And that's the reality. So if we ever have a government that wants to level the playing field, it would really help because most of you can't afford lawyers, and that's the reality.
Thank you so much, Charles. Well, I'm not going to get invited back here if I don't end this now. I'm sorry.
I need five seconds. On the note of what it costs for lawyers, I just want to let everybody here know that there's 4 men in Alberta that are still in jail almost 500 days. Their lives have been destroyed. They have zero money left. They're done because the judicial system has left them behind. And if you want to know more about it, it's all over Facebook, so please check it out.
I would leave you with this. Donate to the Democracy Fund. Donate to the Justice Center. If there is a legal case seeking donations, $5 and $10 adds up to $20 million in a very short time, and we've seen it happen. Donate to these causes, help the lawyers, help the people trying to pay them, because what they're doing benefits all of us if they win. That is one of the things that we can take away from this. We have more tonight. We have John Carpe and we have Dr. William Mackis coming up to do speeches and to take questions and answers. We're going to take a 10-minute break because everybody needs a little fresh air, a little washroom break, and a little water. But I invite you all back. But I thank this legal panel. These are the lawyers that are defending Canada. Look at them. Thank them. They're the ones, they're the minds that are with us, and I thank you all.